All right. Our next speaker is David Berg, who we've used to replace Stephen Jones, who we talked about had a terrible fall. And for you that don't know David, he is truly a lawyer's lawyer. He's tried criminal cases, civil rights cases, commercial cases, personal injury cases. He's gotten 8-figure verdicts in personal injury cases. And for pro bono work, he successfully sued the Ku Klux Klan. The National Law Journal picked David as one of the top 10 lawyers in 1904. David spoke to us before, and several years back, and I mentioned to you that he was selected one of the top 50 lawyers in his firm of 22 lawyers. But he graciously, when I called him last week, agreed to fill in. Really, he didn't have anything going on, a man his age and all. So, when something like this comes up, you call somebody that, really isn't doing much. And so that's why we got David. David really isn't a very interesting person. He really isn't that exciting, but he knows some people and knew some people that were really great lawyers, and that's what he's going to talk about. David?
First, let me say, on behalf of everyone here, Dickie, we are thrilled your license was restored. No, Dickie has introduced me several times over the past few years, and you just come to know him. He's a modest man with an enormous amount to be modest about. Introduce me again, Greg. I got more. First of all, in all seriousness, Amber's talk moved me deeply. I kind of feel like the guy who followed Jesus' Sermon on the Mount. What an enormous amount of truth and bravery to speak about that. I find it very moving for personal reasons, which I've shared with this audience or some of you before. And that is what I come away with. I had a brother who was murdered, and what I come away with is you cannot let a violent death or suicide obscure a beautiful life. And I think Amber personifies that kind of bravery. I was going to speak today about a friendship with Racehorse Haynes and about my friendship with Joe Jamail. And then I remembered that Racehorse and I had engaged in a trial, and there's no tape of Racehorse cross-examining that I know of other than what I have. And I'm going to show it to you today. One thing Dick and I have talked about is how the names of great lawyers fade rather quickly. I say Racehorse to an audience at Georgetown, and they just look at me. Who is that? Or Joe Jamail. Back in 1995, Haynes and I took on the defense of Hamlet in a case in which he was accused of murdering Polonius. We had an insanity defense. Our psychiatrist, who testified for us, testified that after much careful consideration, he had decided that Hamlet suffered from post-traumatic stress syndrome. And this is Haynes cross-examining the expert from the other side. I hope you enjoy this. It does capture his incredible drama, wit, quick wit, and humor.
Ask you, do you have some concept as a disciplinarian in your field that Prince Hamlet, as a consequence of his genius, was more troubled by the ignominy of Claudius' act as against his own father? Would that be more troubling to him, do you think, to learn that Claudius had sneaked up and performed this dastardly deed upon his dear father? Just yes or no?
Yes.
Because of his sensitivity, because of his intellect. Likewise, would you be inclined to believe that Prince Hamlet would be more deeply affected by the fact that he personally, before the time of the appearance of his father, was troubled by the prospect that his mother was adulterously involved with King Claudius? Would that give Hamlet more ground to be upset, distraught?
I think anyone would be upset.
And the more sensitive he is, the more intelligent he is about it, the less clod he is about life, the more he'd be troubled by it, would he not?
Not necessarily. The more he may be equipped to deal with it.
You mean?
And to take
action. The more sensitive he would be.
The more sensitive, the more intelligent, the more his ego strength, the better he can deal with it and take the action.
But that's not inconsistent with the converse of that, is it, sir? That the more sensitive one is, that the more likely one is to be dethroned of reason as a consequence of these
absolutely not. He had a moral sensitivity. I didn't say he had a weakness. I never said he had a psychiatric or a psychological weakness.
He has a defect of reasoning, does he not?
No, he does not.
Never in the play. You think it is rational and lucid? That the record reflects it during all the time.
Absolutely. When he was mad, he was acting mad, and he says at the beginning of the play...
May I have the button pushed that would say to you, Doctor, if I might ask the questions, and you would favor me, please, as a consequence of the judge has instructed you to. Judge, may we have the one lawyer, one witness rule? We now have lawyer witness. This court told this jury right on that we would not have a Los Angeles resolution of this lawsuit. Now we have not one, but two distinguished lawyers jumping in and butting in on the same witness, Your Honor. I'd ask this court to admonish lawyer Reason to please sit down and let lawyer Sussman handle this problem.
You have 4 minutes.
Thank you, Your Honor. What would you read, lawyer Raley, that refutes what this gentleman says?
Gertrude's analysis of the debt.
Doctor, I'm confident that you've become familiar with Queen Gertrude's analysis of the death. I would like to call upon my distinguished colleague, lawyer John Wesley Horden Raley, to read from the transcript, and then I would like to ask you a question from it. Lawyer John Raley, would you please? He's just reading, Judge.
He's a demonstrative exhibit.
Exactly, Your Honor. He's a very big exhibit.
Just read it, Raley. Don't comment on it.
Mad is the sea and the wind when both contend which is the mightier. In his lawless fit behind the arras, hearing something stir, whips out his rapier, cries, "A rat, a rat!" and in this brainish apprehension kills the unseen good old man.
Sign him up, Berger. Did you get the quotation?
I think I got it. I need to know what act and what scene.
Doctor, is it important at all to know the act or the scene?
It's important to me to know what happened before and after.
We cannot both speak.
Why don't you try answering the question and see if you can answer?
You want me to ask the question, see if you can answer? A good plan, Your Honor. I think.
We sometimes have.
Let me put it to you this way, Doctor. What do you make of that?
Would you like to hear my explanation?
Well, answer the question yes or no, please.
Ask the question.
Yes, you heard the recitation by distinguished lawyer Raley. You're familiar with it. It's the recitation of the Queen concerning the conduct of her prince, her son, Prince Hamlet. Correct?
Yes.
Is she opining in that recitation that Prince Hamlet is dethroned of reason, that he is unaware of the seriousness of what he has done, of the unlawfulness of what he's done, of the wrongness of what he has done? Is that what she opines? That he's mad?
No.
What is she saying?
I have to put the scene in perspective for you. This is after Hamlet has told her, do not tell Claudius how mad I've been acting. And when she goes to Claudius right away and says, how was Hamlet? And she says that he was mad as the wind who meets the sea.
That's pretty, the
Well, no,
cause of that issue. isn't it?
but he told her not to say how mad he was, because he did not want Claudius to know the truth, that he'd been feigning madness, and he appealed to his mother. In that scene, he tells his mother, become a virtuous woman again. Don't sleep with him anymore. Don't go to his bed. Do something pure.
Let me ask you,
and in
Doctor.
doing something pure, she told Claudius he was acting mad,
Let
that
me
he
ask
was
you
mad.
this, Doctor. Isn't it, for whatever reason, scientific or not, unusual, very difficult, for a son to make inquiry of a mother about her sensuality? Just yes or no?
That's not a yes or no answer.
Is it unusual or not, Doctor? Isn't the general rule that sons don't like to even contemplate the sensuality of their mother?
That's true.
Isn't, in this case, wasn't young Prince Hamlet bothered and troubled and agonized by what he perceived to be the lust of his mother and her sensuality?
Prince Hamlet was 30 years old, and
Was
he
he
did
or
not
not,
like.
Doctor, despite his age?
He was upset.
Upset, didn't he upbraid her and cross-examine her to tears, where to the point where she thought he was about to kill her?
He was upset.
It's time, Mr. Haynes.
Doctor, I appreciate your candor. I take it that we will not agree, thee and I, on whether or not Prince Hamlet was at the very time suffering from a post-traumatic stress disorder.
No, we won't.
What do you say he was suffering from at the very time that he impaled Lord Polonius through the curtain while Lord Polonius was back there surreptitiously eavesdropping on the most confidential of conversations between a boy and his mom?
He was like you and Mr. Berg, suffering from no psychiatric illness.
Is this a personal attack on my colleague, Mr. Berg?
No, it's a compliment. It's a compliment.
He said no psychiatric.
Okay.
No
Honor.
psychiatric.
He said no?
No
No psychiatric. It's a compliment.
Let me ask you, Doctor, are you, as an expert, saying there's absolutely nothing in your professional opinion as an alienist, an expert, wrong with Berg and I?
As far as I can say.
Go, Mr. Doctor. You're under oath.
I rest my case, Your Honor.
Good morning, counsel, ladies and gentlemen of the jury. I would start just by telling you that in a few moments you will hear an instruction from the court that we have a burden of proving to you, which I believe we've dispatched in every way, by clear and convincing evidence that Hamlet suffers from a serious mental defect, the symptoms of which cause him not to understand the wrongfulness of his act. I consider it an enormous victory thus far that I was able to persuade my distinguished colleague, Lord Haynes, not to argue that Hamlet was out of town at the time of the killing of Polonius.
I have an announcement to make, and then I want to introduce the jury to you. The announcement is Hamlet has escaped.
This was a rigged trial. The jury came back. There were 14 of them. The foreman of the jury was a dear friend, Dr. Bud Frazier, a great heart surgeon and pioneer. And he reported that the vote was 14-2. He was in the minority. He was two who said Hamlet was not rational at the time of the murder. And then the other 12 voted him off of the jury. I should make clear, I loved Richard. He came along as a brother at a time when I needed one. And at my 50th birthday party a couple of years ago, I introduced the world to Haynes's arthritic finger point. In the middle of a trial, he'd say, "You did this," and he'd be pointing back at himself because his... Anyway, I miss him dearly to this day. And one of the great things about Richard that I think we should all be mindful of is that Richard never spoke ill of another person. The one person I know was someone who sued his mother, and he couldn't bring himself to say anything more than, you should not sue your mama. And that was it. And his memory is a blessing. Another man who I grew very close to later in my career was Joe Jamail. And every Thursday, once a month on a Thursday, we would gather some old trial lawyers, not litigators. We don't recognize them as trial lawyers. It's people like you we love and respect, who will tee it up and try it. And we would sit around a table, mostly honoring Joe. Joe would sit at the end of the table, and there was a spotlight from the ceiling, and it seemed apropos. Joe had 1,000 great war stories, some of them true, and which he would tell over and over again. In 2002, I wrote a book called The Trial Lawyer, What It Takes to Win. It's a trial skill book. And in 2014 or so, the ABA asked me to update it, to create a second edition. And so I did. I worked for a year and mostly was talking about the effect of the changes in procedural rules and the way these changes have affected the right to a jury trial. And in September of 15, I looked at my book and I thought, my God, this is really boring. In December of that year, we lost Joe. Joe always returned calls. I mean, he could be in Russia and he'd return a call. And on a Monday, he had called me and asked me to please join him for a drink. And we would get drinks a couple times a week. And then on Friday, I called him. I think I was in trial, and on Friday I called him and I said, Joe, please give me a call. Let's get that drink. And he didn't return my call. And I knew immediately that something was really wrong. And I called his house. And I said, I need to talk to Joe. And they said, of course, and this will be your last time. And I said, Joe, I got one thing that I want to say to you. And he said, what? I said, I love you. And he said, thank you, and hung up. It was then that I decided to update my book with Joe's great trial, Pennzoil versus Texaco, which resulted in the largest verdict in the history of the country that has been affirmed on appeal. At the time, it was $11.5 billion. And I learned an enormous amount, even at my age. I mean, all of us. Isn't it a wonderful thing that you still learn at this age? It's an extraordinary part of what we do. So let me go through with you some of the things that Jamail, just reading the 25,000-page transcript, taught me about trial law. This was Pennzoil v. Texaco. It was tried in 1985. I'm going to give you a quick précis on what happened and how this case came about. The president of Getty Oil, which was the largest privately held company that held oil reserves in the world, the president of that company was a man named Peterson. And one of the Gettys, who was a philosopher and a poet, took issue with the fact that Peterson had spent $100 million buying this ridiculous television channel called ESPN. And he decided that he was going to depose him. And in Houston, the president of Pennzoil was a man named Hugh Lidke. And Hugh Lidke was very aggressive. And so on I think it was December 28th of 84, Lidke went to New York and got with Getty. And let me take you through this very quickly. Lidke offers $100 a share for 20% of Getty Oil. That's on January 2nd. The Getty Trust has 42% of the stock, and the Getty Museum agreed to the Pennzoil merger. Bear in mind that that 20% offer was for the publicly held stock. Getty Oil on January 3rd, their board of directors approves Pennzoil's plan 15-1. January 4th, the trust, the Pennzoil Trust, and the Getty Trust and the Pennzoil Company release press releases saying they have an agreement in principle. And then a guy at Goldman Sachs named Boyes, not David Boyes, just some guy named Boyes, thinks he sees an opportunity to make a commission, to make some big bucks. And he goes behind everybody, and he goes to Marty Lipton of Wachtell Lipton, great lawyer, and says, let's cut a deal and we'll pay you, Texaco will pay you $125 a share. So at that point, here's how it worked. Texaco gains control of Getty Oil by buying up the 46% in the public. Mr. Lipton agrees to throw in the 12% from the Getty Museum that had voting shares in Getty Oil. And the 42% that is owned by the family trust has no choice or risk becoming a locked-out minority. Now, this will be on the exams Tuesday. Having said all that, Joe got a call from Hugh Litke, and he said, what do you do? Joe said, pack your bags, shut your mouth, and come home. Through a series of very quick Jamail moves, they filed this case in Harris County. Now, the elements of Pennzoil's claim of tortious interference with contract, and what I loved was, in such a complicated fact situation, Joe filed one cause of action. And just to review the elements, you had to prove that there was a valid Pennzoil Getty Oil Company contract for the purchase of Getty Oil, that Texaco knew of the contract, that Texaco's interference caused Getty Oil's breach of the Pennzoil contract, that the interference was intentional, and then you had to have been damaged. And Joe had a very simplistic damage model, and he had blown it up at Kinko's, and none of this fancy stuff we do. It was on butcher paper and blown up big as Dallas. And they came up with $7.53 billion in lost opportunity and a like amount in punitive damages. Now, if you'll wake up, now that I've put everybody to sleep, Texaco's defenses were that Pennzoil had no binding contract, and Texaco was told it was free to deal. Now look what Joe did. Why is there a picture of LBJ in a CLE lecture? This is John McKinley, who was the president and CEO of Texaco. And I added him because of the likeness with LBJ. Why am I here again, Dickie? Let me. Now, what I love about Jamail's cross, his theory of a case was call the adverse witness first, then put on your best witness and let the jury decide early on how is the case going to come out. And Joe did some things that we can no longer do. Before trial, like contributing $10,000 to the judge's reelection campaign. And during, well, I've been in the East too long, voir dire examination, voir dire, he committed the jury to a verdict. It's just something you can't do much anymore. This is his cross-examination of McKinley. And his opponent in this case was a great lawyer named Miller. God, I'm forgetting his first name. Dick Miller. Dick Miller always accused Joe of playing dirty pool because he brought this guy McKinley, the president and CEO, to the voir dire examination, to opening argument, and he had him subpoenaed for the trial. Dick Miller was probably one of the greatest trial lawyers of his generation, but I never understood why he would say that was dirty pool. He brought the guy, and the guy was subject to subpoena. He's on the stand, and this is what Joe loved, hypotheticals. That was his favorite kind of question. Sir, he asked McKinley, is it Texaco's policy to interfere with other people's contracts? Answer, no, of course not. If that is the case, then, would you stop anyone at Texaco from interfering with someone who has a prior agreement with the same party that Texaco is negotiating with? As you might expect, the answer is, why, certainly I would. Joe did this all the time. He would put the adverse witness in the position of his client. Sir, if you were struck, T-boned, as you came going through an intersection, and you were harmed badly by someone who ran a red light, would you not seek some sort of damages from that person? And they'd say, well, sure. And then they just admitted Joe's case. I assume, Joe asks, if evidence came to you that such an agreement was in fact in existence, then would you have the obligation to make some study, some good faith effort to find out if in fact there was or was not an agreement between two parties? The answer was, yes, of course I would. I would have to. I did that. Now, because you have to prove intent, he asked, you tendered for Getty Oil intentionally and knowingly, knowing of the existence of the memorandum of agreement that had existed between Pennzoil and Getty Oil, and the press releases announcing the merger. The answer, the memorandum of agreement was, I had not read it. I had been informed by our general counsel that it was not a factor in the museum's presentation of its desire to receive an offer. And look what happens next. This one sentence is magnified in the trial by this question. Maybe you should have read it. You might not be in this courtroom. My question to you is, did you conclude the acquisition of Getty intentionally? You wanted to do it, yes, no question. And you did it knowingly and knew of the fact that in existence at the time were the memos of agreement and the press releases. We did it knowingly, and this is McKinley. He might as well have been arguing for the plaintiff. We did it knowingly and intentionally, knowing that the Broad tape, the old Wall Street Journal, the Wall Street tape, said that they had an agreement in principle subject to a definitive merger agreement. They were going to say there was no contract, was Texaco, because there was no definitive merger agreement. Question, all right, sir, the memorandum of agreement does not say memorandum of agreement in principle, did it, sir? Answer, it says memorandum of agreement. Now, at that point, I don't think there was much question after the first witness, and it got worse, if you can believe it. I don't think there was much question after the first witness that Texaco was in deep trouble. Now Joe takes Hugh Litke and puts him on the stand. And here he is facing this, or here Hugh Litke is face down Texaco. So where does Joe start? Where he should have. He says, question, you have children, Mr. Litke? Answer 5. Question, would you please tell us their names and ages, please? Answer, I wish you didn't ask that in front of my wife. Question, well, do you at least know their names? Answer, yeah, I know their names. Now, Hugh Litke's first business partner in Zapata Oil was H.W. Question of Mr. Litke, Mr. Bush is no longer a partner of yours, is he? Answer, no, when he went into politics, he sold out totally. Then Judge Ferris, Anthony J.P. Ferris, says, I'm not sure you meant that the way it came out. Joe says that. Then the court says, do you want the court reporter to read it back? Mr. Jamail, no, I think I'm going to leave that alone. Now, how much time do I have, Dick? No. 5 minutes? 4 minutes? 3? You know, I got over the fact that I'm second choice, okay? but not entirely. I'm going to bring this to a quick close because I want to address another matter before I sit down. The night before Joe was to do a closing argument, he got a knock on his door at 9 o'clock, and he's sitting at 9 o'clock, he once said, was the latest he's ever been sober in his life. And it was Darrell Royal and Willie Nelson, and they drank away the night. And Joe told me the next day, he just had to lean against the table to do the closing argument. A question came out on punitives. By the way, Dick Miller did not put on a damage expert. He thought he had it won. It was a tactical mistake because the jury sent out a question asking, how do you define wanton? And the verdict was $10.53 billion. Now, I was going to spend an hour and a half on a trial of mine and the effect that Joe had on me. But Mr. Gregg, a man who has never met a man or a woman who he was not willing to humiliate in front of 300 people. I want to commend David and Guy for what they're doing at the legislature. A few years ago, my wife and I moved to New York. We moved for health reasons. The Texas legislature was making us sick. And of course, one day I said to her, honey, I call her honey, we're just not paying enough taxes. But I want to speak to you about our unique voices. Studies show, in all seriousness, that our voices, trial lawyers' voices especially, make a difference in elections. And we should raise those voices, is my suggestion, to push back, to speak out when someone says the Justice Department has been criminalized, has been weaponized. Tell that person to call Hunter Biden and ask him about the double standard. Make sure you speak out, you push back. When someone says the election was stolen, the line that I hear from the right wing or the MAGA supporters is, the reason why we lost 61 cases is because we didn't get to put on our evidence. You might explain to them that you have to have a plausible case. You might quote Rudy Giuliani when he was asked by a judge in central Pennsylvania, a federal judge, I don't see any facts in this pleading. And Rudy responded, quite honestly, we don't have facts, but we have a theory. Push back, speak out when you hear any sort of lie about our judicial system. Speak out about the loss of individual liberty. Jury trials were the canary in the constitutional coal mine, and they chipped away at us until it is very difficult to get a case to trial. That was, of course, the effort of big business and combined with chambers of commerce and the Supreme Court. Even the liberals helped push that along. And if you read the cases, even Daubert, Justice Rehnquist, of all people, was one of the strongest advocates of our role, of the role of jury trials, the only form of real democracy in this country. All the rest of it is representative. This is direct. And when you hear people undermining faith in the judicial system, tell them you are undermining faith in the rule of law, which distinguishes us as a country. Remind them of Shelby County versus Holder, which attacked voting rights of minorities, and the predictable onslaught of voter suppression that came after that. Remind them, most recently, of Dobbs, which abruptly, for the first time in the history of this court, ended a constitutional protection. And I can tell you as a man in a feminist family. The women of this country and the men who care about them are outraged at the cessation of health care. Read abortion, however you want to say it. This court has no respect for stare decisis. It is, as I suggested to the good professor yesterday, apparently just a wing of the Republican Party. Speak out, push back when they talk about the criticism of Justice Thomas. Talk to them about a House of Representatives that will not impeach and a Senate that would not convict a justice who's on the take. We can't be blind to these things. We cannot sit quietly. I know if you feel like people I know do, we feel overwhelmed by the lies. How do we talk to people? We speak out, we push back. We are trial lawyers. We can do that. Thank you.